Right. Sub-Sire. Revolution. Reason, I don't know. Resun Ltd. What's going on? So people should start coming in here possibly. Who knows? But here it is. You can see it looks like somebody might have tried to open it, but it is still sealed. And let's get into it. This is the results from the sticker pimp trial. No idea what it's going to say. What's up, Therese? Okay. So it's going to be a little bit of reading here. This is not that much. Looks like 2 pages. It's like about 2 pages. Verdict and sentencing order. So that's not good. Sounds like he found me guilty. So all parties appeared for trial on 2/3/22 at 1:15. The state was represented by attorney John Blanchard. Defendant appeared self-represented. Defendant is charged with 1 amended count of criminal mischief under RSA 634-2-1. Defendant formally requested permission to conduct audio and video recording of the proceedings, which was granted by the court. I demanded it. It wasn't any request involved. But it's neither here nor there. Based on testimony and the exhibits admitted into evidence at trial, the court finds the following facts. On 3/9/21 at approximately 1:40 a.m., the defendant approached the front doors of the Manchester Police Department located at 405 Valley Street, Manchester, New Hampshire. The defendant took several adhesive stickers and attached them to the clear glass of the front doors of the police department. The defendant's actions and identity were captured on video surveillance system used by the Manchester Police Department. The defendant admitted that he was the person seen on the surveillance footage, and he admitted that he placed the stickers on the front doors. Officers of the Manchester Police Department had to use tools, cleaning products, and physical labor to remove the adhesive stickers from the front doors. Now, I don't know where he got that from. They used tools and cleaning products. Never saw that testified to. If anybody's watched the video, I'm sure most of you have. I do not recall anyone testifying, specifically the officer who testified of removing the stickers, of using cleaning products and removals and anything of that nature. She just peeled them off. So the original complaint listed the offense as a Class B misdemeanor and alleged that the defendant recklessly damaged the property of the Manchester Police Department, causing damages under $100. On or about 5/13/21, the state amended the charge to a violation level offense and amended the narrative portion of the charge to read, defendant having no right to do so, nor any reasonable basis for believing or belief of having such a right, did recklessly cause temporary damage to public property when he defaced or made other unauthorized alteration to said property when he applied stickers to the main entrance doors of the Manchester Police Department. And there's another thing which was testified to. He claims that he sent this to me in an email and not through U.S. Postal. It has to go through U.S. Postal, and I never got it. It may have been on an attachment. I'm going to have to go back and look, but I never opened the attachment, and I've never saw this amendment here, just for the record. So they amended it from a misdemeanor to a violation, so they can only find me for a violation, guilty on a violation right now. But temporary damage? What is temporary damage? He's leaving this open for an appeal, 100%. So the amended complaint mirrored updated statutory language in RSA 634.2.1, effective January 1st, 2021. Yeah, so they made amendments to the criminal mischief statute to include vandalism and defacement and all these things that are already covered under other laws. So they added like a whole nother paragraph to what criminal mischief is, and I believe it was because of the stickers, in order to charge people with criminal mischief for stickers instead of just a simple graffiti charge, which is already on the books. So they're replicating pre-existing laws that are already on the books that they could be using. They're making other ones that are more purgative to people. Anyway, I digress. So during his own testimony, the defendant openly admitted that he was the person seen on the video and that he was the one who placed the stickers on the front door of the police department. The defendant argued that he was engaged in protected political speech under the First Amendment to the U.S. Constitution in Part 1, Article 22 of the New Hampshire Constitution. The defendant also argued that the statute in question was unconstitutionally vague and that it was discriminatory as written and as applied. The defendant argued that the placing of the stickers was not damage within the meaning of RSA 634.2, and hence the state cannot prove a material element of the crime of criminal mischief. You can't. There is no damage. Damage isn't even defined in the criminal code. So you have to go to the typical interpretation of damage. What is damage? It's breaking something, damaging it, right? And the courts, New Hampshire courts, have said that pecuniary loss is damage. So if they would have called in DPW or a cleaning service and they had to come out of pocket to pay $100 to the cleaning service to come and take the stickers down, then that would be pecuniary loss, which would be considered damage, quote unquote. But that's not what happened here. The officer took those stickers off on her own volition. So the court does not find this argument persuasive, obviously, as the statutory language in 634.2.121, the new law, does not necessarily require damage, but unauthorized alteration. But now, where is that defined in the statute? Where is unauthorized alteration defined? So it leaves it open to interpreting anything. Could be spitting on something, could be an unauthorized alteration because now your spit is on it temporarily. Throwing your coffee. I mean, it's ridiculous. So throwing my coffee on the front door of the police station would be criminal mischief and damage. I mean, get over it. So the court will now address the defendant's free speech arguments. Defendant argues that the state and national constitutional protections on freedom of political speech prohibit the application of criminal sanctions to his conduct. Defendant cites no authority from any appellate court that construes I don't need any authority. The Constitution itself is the authority. It is that authority. It's the supreme law of the land. I mean, so as a violation of my freedom of speech. Still, the defendant argues that the right of free speech is set forth in the First Amendment of the National Constitution in Part 1, Article 22 of the State Constitution prohibit a conviction in this matter. Presently, Part 1, Article 22 of the New Hampshire Constitution provides free speech and liberty of the press are essential to the security and freedom in a state. They ought, therefore, to be inviolably preserved. There's no authority cited that construes the First Amendment free speech provisions or Part 1, Article 22 as voiding the content-neutral criminal statutes. It's not content-neutral when it's applied the way that it was. How many other people are charged with stickers? Nobody. Nobody but people that put up white rose stickers. So all these businesses that put up stickers, none of them get charged. Sorry, I lost my place here. As observed by the Judge Kavanaugh, whereas here the government applies a restriction on defacement in a context-neutral and viewpoint-neutral fashion, there can be no serious First Amendment objection. Well, that's not binding whatsoever. It has no bearing on this case and the facts in it. So the court finds that the right to free speech is not a defense to damaging or tampering with the property belonging to others. It's my property. It's our property. This is public property, and there was no damage. They're just trying to be sophisticated wordsmiths and twist it into the sticker is damage, and we know it's not. So let's continue on. I don't want to waste everybody's time with this thing. Blah, 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 even for ostensibly political purposes. Hence, the court holds that neither the state nor the national constitution's protection of the freedom of assembly prohibit the state from obtaining a conviction on the charge of criminal mischief. The court interprets the material language from 634.21 in the amended complaint or any other authorized alteration to public property in the common usage. Hence, so this is what I'm saying. Like, I had no notification about this law being changed, and I was assuming that it was all just damage, but they changed the law to cover these stickers. They 100% did that because we put stickers on City Hall. I do not doubt it at all. Blah, blah, blah. So hence the context. The stickers to the vertical surface comprise a part of the municipal building. The court holds there was an alteration. So there was an alteration. It changed the nature and appearance and use of the public property involved. It does seem clear that the defendant's conduct in this case could also constitute a violation of the city ordinance concerning graffiti. While it is constitutionally permissible for the prosecution to pursue two different legal theories at trial, the court may only impose a sentence as to one of those alternate theories. In this case, the state chose to permissibly prosecute the matter as a violation-level criminal mischief as opposed to the city ordinance. So why have the city ordinance at all? Obtaining a verdict on this one charge does not violate any double jeopardy provisions of the court finds that the state has proven the elements of criminal mischief beyond a reasonable doubt. Court does not find my First Amendment claims to be applicable. The court is likewise not persuaded that the statute's unconstitutional or being applied in an unconstitutional manner. So this is it. This is tyranny. Tyranny has seemed to have temporarily won this battle. So they've proven the elements of the crime and blah, 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 blah. Now, honestly, if I knew about the change in the law, which was not anywhere on Google, it's not updated on the state website or anything, I probably would not have pursued the case, but who knows? Here we are, and I will appeal. I'm definitely going to have to appeal this thing. So thank you all for tuning in. Have a good night, and hold the line. Don't give up. You know what I mean? Just because you don't get your way every time doesn't mean it's time to quit. So keep it moving.